probate, which is being recorded. So on our panel, of course, we have Rick Smith, who's an agent in our office. He's been licensed as a real estate broker since 1986. Side note, I was still in high school at that point, so he's been doing this a very long time.
That's okay. When I teach orientation at SCORE, I ask them, I said, hey, new agents, how many of you were born after 1986? Over half the hands go up, so I'm used to it. So are you, Chuck. Don't think that's fine.
I can't hide, I can run.
So Rick, of course, is a probate and trust specialist, among other things, but he spent a long time developing and really nurturing that core of his business. So he's going to talk to us about what he does. And then we have to his left, David Lee from Sweeney Mason across the street, who is a trust and estates attorney. He's been practicing for 13 years in the area. And he's going to help chime in about what's useful for an attorney to get from the realtor that's helping them with their clients. So his perspective should be very helpful to us in terms of how to market ourselves to attorneys and how to present ourselves to attorneys and give them what they're really looking for. And last, right here on my left, is Joan McCreary from JMPO, and she is a home organization specialist. And if you've ever done any work with probate or trust, you know that there's often a lot of things to deal with at the end of that. So having a relationship with a person like Joan is invaluable to getting this type of business, because there's literally no way you can get it done without her. So she's going to give us some guidance on how to work with her, what kind of things she can offer, and how everyone can work together as a big team to help their clients who are, of course, are often dealing with a loss in their family. So it's all up to you right now.
So I'm going to give each row a book that I want back. This is something that I give to each one of my clients, and it's also something that I give to attorneys, because why would they want to work with me anyway? Right? They have to have a clue about who I am, what I do, and how I do it. So that generally handles it fairly well. So just take a look at it, and then in the very end, you give it back. This is the first edition of that. There's a new one that is being created because things change as you move forward, and that's that. So I want you guys all to see that, because you have to have some material. You have to have some bona fides. You can't just call up an attorney and say, hey, I'd love to get together for lunch. I'm paying. Why? Who are you? They might think you want to actually create a trust, okay, which is fine. You should have one. But the point is that if you want business, you need to be able to sit down and speak with them and bring something to the table, because these are professional people, David will tell you, and they want results. They don't want to work with somebody who's going to mess up their relationship with, guess whose client it is first? Theirs. Okay, you got to keep that in mind. And they went to school longer than we did, more than likely. So they paid a lot of money to have that client.
So Rick, you want
Yes.
to tell us, how did you get started working on probate and trust sales?
Back in the, oh, this is gonna get bad. For a company that no longer exists, but Chuck Grubb and Ellis, remember? I had a friend of mine who was best friends with the county clerk. And he said, Rick, I got this program. I can go down and I can get all the probate information from the basement in the county records. I go, program like on a computer? So he would bring me once a week a, ready, 5 1/4 inch floppy disk that had all the data on all of the probates that were filed that week that had property in them. So I would upload it into my system, and I would send out a letter and a package via US mail, because we didn't have the internet then. And I would send it to the administrator or executor of the probate transaction, and I would send it to their attorney. And, after a while, I started getting some business, and I began to list about a property a month through that. So that's basically how that got started.
And then since that time, you've become a certified probate real estate specialist. When did you earn that designation?
Well, I just decided that I should have something that actually, besides what I'd done, to do that. So I went and took those classes and passed that test. By the way, that's a designation that's offered by a third-party company. There's also a CAR designation for that. And I recommend you do that, because, if you're starting off looking to get into this kind of thing, and you've never done one of these transactions before, what are you bringing to the table, right? So getting some knowledge, getting some instruction, getting a basic understanding about how probate transactions and trust transactions work, because they're slightly different. But the mistakes that you make if you're new can be really tragic. I mean, you could be ready to close escrow and then you realize that you've got a big problem. And that's going to delay things. Maybe you lose your buyer. You will have definitely at that point lost the confidence of the attorney you're working with. And the clients won't be thrilled either. So that's getting that designation or one like it is a very good idea to start.
Do you recommend any program other than the other one, like you mentioned CAR and other?
Those are the only two I'm familiar with. There's a CAR, there's no NAR designation that I'm aware of. And it's just a CAR, and this is a separate third party one. This separate third party one actually offers you the opportunity to have electronic files sent to you regarding the probates in the county of your choice. So you pay for it, but it might be a way to get started.
Repeat what it's called, the third party.
It's, I forget the name of the company, but if you Google the designation, it will tell you. What is CPRES?
CPR, yes.
Yeah, CPRES, Certified Probate Real Estate Specialist.
And I have the car one, and I think it's called like probate and trust.
Right, something like that, right.
So after you got into the business, how did you go about making the connections with attorneys and fiduciaries and other folks that funnel these type of leads into you?
Good question. So I was going after the clients basically, and I was listing property, and some of these people were from all over the country, and they didn't want to come out and deal with the probate scenario because they were the administrator or the executor, and they didn't have to be present when they're present, when they were confirmed as such by the court. The attorney handled that. And so I was getting one-offs, and then I thought, wait a minute, after a couple of years, the light bulb went off. I was very slow. And I realized that I'm going after the individual clients. Why don't I think about going after the attorneys who have multiple clients? And if I get a relationship with them, maybe we can do business together down the road. So that's when I started doing that. So I handled the probate for one particular attorney in Roseville. I tried to turn it down. The woman was desperate. She had hired 2 realtors prior to this, couldn't get the property sold. I went up there. We got the property sold, and then I used that to leverage my way into lunches and meetings, et cetera, et cetera. I've been working with this particular attorney for over 22 years now, and I've sold all of her children their houses, et cetera, et cetera. And one year, the best year I've ever done with her, I had referrals from her that were over 11 million in closings, which is, that doesn't sell it.
Right. So let's turn to David. David, what kind of circumstances lead you to reach out to a realtor in your business?
Sure. So let me just start off by thanks, Judith, for inviting me. And I am an estate attorney at Sweeney Mason. We're across the way. I'm a certified specialist in estate planning, trust, and probate. So I have a lot of experience in this area of the law. I've been a licensed attorney since 2010. I guess I want to speed off with what Rick said real quick. In '86, I was 1 year old. So does that make you feel bad?
And you have hair. Go ahead, rub it in.
In any event, what makes me reach out to a realtor is I have a probate. I do a lot of probate work. A lot of the probates in Santa Clara County require the sale of real property, right? So if you have a piece of real property and someone passes away without a trust or other estate planning documents, probate's required. So my first pitch to all of you is if any of your clients are buying homes without a trust, they should reach out to an estate planning attorney. I'm happy to pass out cards if you guys don't know anybody else, right? But that's my first pitch. If though you happen to have a client who passes away or you are retained by someone who has lost a loved one with real property, odds are you will be going through probate. So why do I reach out to realtors? Well, I need to sell a house and or the client needs to sell a house and I don't know how to sell a house. That's not my area. So when I get hired by a spouse, surviving spouse or kids to deal with a probate, and I see that there's a piece of real property, I tell the client to reach out to a realtor if they know someone, and if they don't know someone, then I will provide them with referrals of realtors that I've worked with or have helped me personally, or sometimes I do get fancy marketing materials in the mail and I'm like, well, this looks like pretty interesting. I'll reach out to that person, right? But most of the time, my referrals are people that I know or that I've worked with in the past. So that's how I would reach out to anyone in this room with regards to a probate administration, right? And then once the administrator is appointed, then the realtor can take it from there to start listing the property and getting everything ready to go.
Are you looking for any type of specialized skill set from those realtors? I mean, obviously, you're not just going through the phone book and just picking.
No,
right?
I don't do that. Yeah, no, I mean, those designations that Rick mentioned are helpful. I mean, I think a lot of the times the realtors just need to know that a probate sale is just a little bit different than a normal sale. And maybe those designations teach you, maybe these seminars teach you kind of how, where the differences are. But that's kind of just what I'm looking for originally. It's just someone who knows the probate world, and then really it's about the relationships. I don't think it's probate in particular. I think someone can learn how to do a probate sale. But for me, it's, do I like the realtor? Do I want to work with the realtor? Do I think that realtor will work well with my client? And then, I'm going through a probate now up in Del Norte County. I didn't even know where that was. I had to Google it. It's way up at the Oregon border. And that's a probate sale. I don't know that particular realtor, but we're gonna work together to figure that one out. So it's just a matter of kind of understanding the process, understanding the area, and then really the relationship between me and that realtor, or that realtor and the client.
Yeah. So Rick, you have some longstanding relationships with attorneys. What do you think that you offer to those attorneys that maybe other realtors don't?
Actually listing and selling the property, look, we can all do that. All right, but there are some situations involved in probate and in trust sales that attorneys are, they don't want to have a headache, a problem, or a difficulty. You don't want to look bad to your client. You don't want to pick a realtor or refer a realtor, and then that realtor coughs up a hairball in the middle of the deal or something goes wrong. And trust me, it happens. I mean, you pull a preliminary title report immediately upon even meeting a client. And you find out what's going on. I mean, these are old folks that have passed typically. I mean, at least out of every 20 listings I take, at least 3 to 5 of them have liens that have been paid off, but not reconveyed. So we got to deal with that, right? I mean, I've got the title department at Chicago Title is absolutely killer in that. I mean, I just had to get a bond for the first time this week. I mean, they can find these lien holders and get these liens released like nobody's business, but that's a critical issue there. But one of the biggest things that you can bring to the table is that, and you're probably going to agree with this, there are sometimes is more than one heir. Sometimes with more than one heir, they don't see eye to eye. No. Shocking, I know. But here's the deal. That's a burden that I take right off the shoulders of the attorney, because what's the biggest asset that they're all arguing over? Where's all the money? Money's in the real estate most of the time. Not all the time, but 90% plus of the time, the money's in the property. And these heirs can be really weird. I've had them not be in the same room with each other. I've had them fly in from different states on different days to meet with me so they weren't in the same state with each other. I'm not kidding about this stuff. I've got one right now where the 2 co-trustees, who are the only heirs, live across the street from one another, okay, and won't see me on the same day. All right, this gets really strange. I've had those situations, and I could go on. But the key is that I'm working with the attorney and I'm saying, listen, problems, issues, difficulties, anything related to the transaction or the property or the differences and headaches between the clients, send them to me, I'll take care of it. And that's one of the bigger things I can do, because it helps smooth the road. So the attorneys are dealing with the legal issues. They're dealing with, hey, wait a minute, you really can't do this. We're gonna have to work that out. We're gonna need you guys to both see eye to eye on this. Let's go talk to Rick or something. And I usually smooth the road by then, so that we can at least come to agreement that, well, aren't we looking for the most net income to the estate, and wouldn't we like to do that in a way that involves you guys not seeing or talking to one another? And they go, you can do that? Say, yeah, you just talk to me, all right, and we'll take care of it. That's a big deal to most attorneys. I mean, I don't know how you feel about that.
That's fine with me. You take the headaches, right?
Well, that's the correct answer. And guess what? You take the headaches. Because doing this as long as I have, I mean, I'd love to say, I've seen it all. You can't even imagine. I mean, I've had one heir show up with Santa Clara Police Department in tow, and the heir that was at the property already had a private security firm at the property, just so they could meet and talk. This is how things happen, all right? Now, wait, I did one with 16 heirs that went smooth as glass, and then tragically, one of the heirs' parents died during the transaction, and then I handled that transaction also. So it's just, but that's a big deal. The personalities, the relationships between siblings, those types of things are seriously whacked out about 25 to 30% of the time. So if you're not prepared to deal with those, well, either get ready or get out, because it's gonna happen.
Who's your crazy client that you have right now, your heir?
Well, these clients are, look, this happens a lot. You get one client that was taking care of mom or dad towards all the way through the end. That client lives in the property. You go out and you see the property and you go, what happened here? Okay, because mom and the boy or the daughter lived in squalor. Okay, how come? Well, that's because the boy hasn't worked for 33 years and mom supported them on her Social Security and they didn't have very much money. And now that one is telling the other 3 siblings that, well, you know, mom wanted to give me the house, I should have it. You know, and it's like, hey, the house is paid for, it's worth $2.4 million. You don't get it. Well, how about if I buy you out? Okay, I've done literally hundreds of these transactions since the mid-90s. I've had this many successful buyouts. And actually exactly this many. The other one was a miracle, didn't count. So they can never do that. They think they should do that. Well, shouldn't I get a discount? And don't even talk about Prop 19 and how that changes things, because that puts a whole nother spin on what happens to a direct descendant being able to live in the property. Because in our area here, the first $1 million is not a problem. Well, when did we pass that? 2003? So we have issues there. So clients can get strange, and the hardest ones are when one of the heirs is living in the property.
You got a question? Oh, yeah. Go ahead, sir.
So Rick, from a perspective of a newer agent, right? If we want to start marketing ourselves to lawyers and other vendors about, you know, handling probate and trust sales, what would be the 3 or 4 bullet points, our value proposition, our elevator pitch that we should use to start creating those relationships?
Well, the first thing I would do is I would get some knowledge, because you've got to speak their language. When you talk about what's going on, you're talking about administrators, executors, the Independent Administration of Estates Act. I mean, all sorts of stuff, you know, overbids and things like that that occur in court. You have to have at least some knowledge of the process before they're willing to at least consider you as someone that might be able to handle a transaction for them. I mean, you know, everybody did their very first real estate transaction, but you probably had help. So you're probably going to need help on your first one of those, and that's not such a bad thing. After that, it's just a matter of learning the information. And by the way, if you don't have a trust yourself for your personal property and all those things, well, then the first thing I would do is, you know, spend the 2 to 5 or 10,000, whatever, it doesn't cost 10.
Not 10. Don't pay 10,000.
But get a trust and understand what's going on, because, you know, once you get to figure out like where the property goes and all the accounts you have and all these other things, you're going to get an intimate, detailed instruction manual from your attorney about how trusts even work. And that's a very good way to start there. So those are the 2 main things. Get educated about the process. And if you don't have a trust, get one yourself so you have a clue. By the way, the trust attorney that you choose to have your trust done could be, who knows, the very first attorney that you start to do some business with.
Great advice.
Thank you.
Thanks for taking with me wherever I go.
So Rick, obviously, in order to do this type of business, we need the same toolkit that the rest of us have. But you're just talking about hoarder situations, family in the home for 33 years with no one touching the property. Does that call into play additional resources that you may not use on a garden variety transaction of a family home?
Joan and her company take care of everything. When I say everything, what I mean is I don't care what the property looks like when I get there. I don't care if the yard is full, the garage is full, the house and the attic are full. I don't care what the contents looks like. There's two things I know for sure. Joan's team can handle it, and I trust Joan's team implicitly. So tell them what you do.
Thank you, Rick. That's a great introduction. So hi, so I'm a certified professional organizer. I've been doing this for 14 years and I've built a company with a staff that is immensely trustworthy and reliable. And we are a soup to nuts, full service and flexible service for handling the contents of the property when that's needed. We can come in at any stage, whether it's at the very beginning or the family has just given up, thrown up their hands, like, we can't finish this on our own. We've done everything we can you help out? So what we are very knowledgeable about trust. I do have a trust, and I've had 2 trusts. I've amended mine, and it's a great learning resource. I totally agree with that. I started working with professional fiduciaries about 10 years ago to figure out what was in a home so beneficiaries could understand what was in the home. My first trust job was arguing beneficiaries. One lived in the second house on the same property, but was not allowed in the main house. That was like, there was a court order against being on site without the attorney who was representing the trust or their representative. So I ended up being the site representative, which is very common when you're dealing with what they call the tangible personal property. All right, that's different than real property. Tangible personal property, TPP, is a good acronym for that. That's our jurisdiction, so to speak. And so we will be the independent, neutral party on site, going through everything, figuring out what the value is there. And value is going to be a really tenuously defined thing, right? Value is $1,000 item if we sell it, or is it really emotionally valuable to the parties? And we can't know that, right? Nobody can know what's emotionally valuable and what the sticky point is. It could be that candy dish that ends up derailing the whole thing. We have people arguing over baskets when the property's worth $3 million and we need to get this on the market, but we got to deal with the baskets, like we can't. So, you know, we're gonna help usher the process through so that we can get the house ready to be listed. And you're right, we can deal with just about anything. We may not personally be the ones who are weed whacking the yard, although we have done that, clip down things so that we can find the stuff that's been left behind and get that out. There are sometimes, I don't know, if they're not really antique things, but they're worn elements that are in the yard, in the shed, in the back that we have to get out because the family may want that. We've uncovered everything from 1940s band memorabilia, but stuff like boxes of sheet music and instruments and uniforms that a family member had worn in their musical career 70 years ago. And the family wanted that, but it was almost buried. We've also actually found buried treasure. So we do a ton of paper review, which is often needed in order to discover assets that might need to be incorporated into the probate or trust administration, whether they're stocks or coins. We find money records. We find things that say, by the way, I buried something under the house. There was an envelope that opened after I'm gone, written in dated 1987. We took it to the fiduciary, opened it together. It described where he had buried almost $500,000 in coins under the house. And that little envelope was buried in a file drawer amongst 4 different huge filing cabinets. So it can be really worth it to the estate to take the time to look. You don't know what you don't know. And somebody can tell you, and this very treasure one is exactly the same. Somebody can say, I've been working with this client for 10 years. I know everything about this client. I have all the, this was a professional fiduciary who's been in the business a long time. We don't need any of the paperwork. My process is we look at everything. It's okay, I trust you. And guess what? We found that document. It would not have been found if you had just taken all the old files and checked them.
So, sorry, so when you have situations in which, you know, the different heirs are like not on the same page.
Yeah.
Who do you go to? Do you go to the attorney?
So
Do you go to the real estate agent? How do you handle that?
Yeah, so it really will depend upon who is the legal authority for that property. While Rick is really wonderful, he is truly what he says. He can handle everything and he's willing to step in and be the representative for the trustee, if the trustee will allow that to happen. Sometimes they don't allow that to happen. They want to be in charge. But when you bring in another vendor, especially like myself, I will only contract with the trustee. So sometimes the trustee is an attorney, but not usually. Sometimes it's a fiduciary. Often it's a family member or a friend, whoever's listed and is the actual trustee for that property, whether it's co-trustees or single. That's the person I have to report to. So I will ask them how they want to handle beneficiary things if there's a contest. They often will then go to their consulting attorney. So David may be the consulting attorney for the trustee. He may not be actually doing the administration, right? So the trustee would say, David, can you help me interpret the terms of the trust? And so then David would say, well, look, it says you have to split it equally. So now we have to come up with a way, how do we split this equally? Is this a monetary equalization? Is this a even, selection? So they come up with a process to do that. Sometimes I'm the one suggesting, here's how we can do this fairly. And then we try, it's really a collaboration. Yeah, we have.
I have a trust as well for my family. And you mentioned trustees, but really, aren't you working directly with the executor of the estate? Who's
So
the
the
one that's authorized to make the decisions for all the trustees?
Tell them about terminology.
Yeah.
So that's, it's really a terminology thing, yeah. Go ahead.
So when you're dealing with a trustee is the person in charge, like the leader or the manager.
So that's synonymous with executor?
No, right? So when we're dealing with probates, meaning a probate administration in court, that's when an executor is appointed.
Yeah.
Right, so a will nominate an executor, and a will has to be supervised by a judge. So that's what probate is, right? Probate is simply the court supervised process where a will, or when there is no will, the assets are processed through the court system. And that's when an executor or an administrator gets involved. If we have a trust, which is what we were talking about in this particular situation, then the trust document itself will nominate a trustee. And the trustee is in charge of the trust assets. So it's just two
Or
different.
it may nominate the co-trustees,
Got it.
which I highly disrecommend.
Yeah, brokerage fees go up when there's co-trustees.
Okay.
They don't really,
That's
but
a good
it's,
question.
it's an automatic red flag.
Just a comment about probate and how clear outs work with probate. There's a probate referee gets nominated or assigned by the courts when an estate goes to the probate level. And the probate referee has requirements to meet in order to satisfy the resolution or administration of the estate. When it comes to tangible personal property, typically they want an itemization of things and they want some kind of value assigned, and they want to know that it's being sold or distributed according to whatever the terms of probate are. So for us, most of the properties that we go into don't have high value items. Maybe aggregate, there's a value of, I don't know, $5,000 to $10,000 worth of stuff. And that's hard to justify bringing in a full appraiser, a licensed appraiser to come and appraise everything. So when you have a higher value estate, maybe it's $20,000 to $100,000 worth of stuff. You have art, you have a lot of gold and silver. Maybe it's worth bringing in an appraiser to actually document that value. For the lower level, often the probate referee is satisfied with somebody who understands market value of general things. So we will do, in fact, I'm doing one today, go to the mobile home, I'm gonna take pictures of everything, make a list, bedroom, and it's just gonna be general stuff, bedroom furniture, kitchenware, living room furniture, rugs, etc., home decor, and it's gonna be backed up with photographs, but it's just gonna line items with a general market value. This is what I could sell it for at an estate auction, which is what I do, how I clear stuff. I'm not an estate sale person. In the traditional sense, we do estate auctions, and I will tell them what we could sell it for. And then that gets submitted by the trustee or by the administrator to the probate referee. And if they want more detail on that, then they'll come back and say, we need more detail on this. I see this picture. Can you explain why, what this is? And usually that's fine. Once they sign off that they've got the detail they need on the TPP, then they'll allow the state administrator to go forth and liquidate. And then some of those things might be itemized in a will, and those have to go to those beneficiaries, and then the rest would just get sold off.
Is that the point where we see no court confirmation necessary? They've already gone through the liquidation part of it. They've already gone through. Because what is the court I'm just trying to figure out the process. This obviously needs to happen. Before it can be clear. Okay.
So what she's referring to is what's called an inventory and appraisal, right? And that's where the administrator so we're talking about probates here. This is not a trust, right? It's a situation. So when we have a probate referee is appointed, like Joan said, and the lawyer typically will prepare what's called an inventory and appraisal. And that is where we get the information about the personal property. Now, she's correct, $2,000 to $5,000 is generally where personal property lands. And that's submitted and the referee generally will accept that. I've only had a referee object one time. In all the probates I've done, they take $3,000 or $5,000 and they move on. What you're referring to though is what happens when the physical house is sold, right? Joan's been talking about personal property. Generally, that doesn't require court confirmation as long as all the heirs and the administrator kind of are okay with this. But when we're dealing with the actual sale of the real property, there's two situations that you'll encounter. One is when the administrator or the executor has what's called independent authority, and one where the administrator or executor does not have independent authority. Again, vast majority of cases, my administrators, when I'm pushing the probate forward, has independent authority, right? So the reason why I push that is because real property, when sold, doesn't need court confirmation, right? So the administrator will let me know that they've hired a realtor and the house is on the market. And I say, keep me informed every step of the way. I need to know exactly when that house is listed. I need to know when you get an offer. I need to know when that offer is accepted, right? So if we're in the situation where there's no court confirmation, where we have independent authority, then as soon as an offer is accepted, the client, my client, the administrator, calls me or emails me and says, like, we got an offer, here's the purchase documents. And then I fire off what's called a notice of proposed action, right? So this is a form that I prepare, that a lawyer would prepare, and it gets mailed to all heirs or beneficiaries of a probate administration. And that is, you've all seen this on your car forms, 15 days, right? So the notice of proposed action gives all heirs information about the sale. Generally, we're going to sell a house in Santa Clara County for $2 million. Realtor commission is, I don't know, 2.5% per site, whatever it might be. That gets mailed to all the beneficiaries. That starts a 15-day clock. Where as long as no one objects within those 15 days of that sale, you're good. The realtor can proceed as it was a normal sale, right? No court confirmation. However, if somebody objects within those 15 days, then that just screeches your whole transaction to a halt. And I say, you just have to wait. And then it's a whole different ballgame going through the court process. There's a publication requirement, there's an overbid process that would require kind of a whole class in and of itself. But those don't happen very often. I think for you guys in this room, you just need to know about independent authority, not non-independent authority, and kind of the differences when it comes to alerting the attorney as to where you are in the transaction.
Rick, how do you handle those scenarios when you're talking to buyers who need to know that, I mean, who need to be educated about potential derailment in the probate sale?
It's always possible because somebody could come out of the woodwork. But generally, by the time in a probate transaction that you're getting ready to go on the market, you know who the players are. We know who all the beneficiaries are. Those are the ones that are going to be receiving the proceeds from the sale. And we have an understanding of what's going on. That's when I'm working very closely with the attorney, because the attorney is in touch with the beneficiaries. They're not the executor or the administrator. They're not the ones that sign the paperwork. They're the ones that are, maybe live who knows where, but said, by the way, when do I get my share? So he's in touch with them. I'm talking to David and saying, hey, do you want me to talk to them? Are some of them becoming a pain in the butt? Do they want to know a blow by blow of what's happening? And then I can take care of that. But the bottom line is that you get a feel for what's going on. So when we're getting offers in, I just tell them the process. I said, listen, we got to send out, the minute we get an offer, we get an NPA. So you got 15, the sellers have 15 days basically to goof this up. Okay, and then give your buyer a headache. But here's my feel. And then I just tell them what I've done. There's 5 years in this. They all seem to be on board. I don't see a problem coming up here. So I'm just letting you know my opinion. But the 15-day process is a legal process. Sometimes what happens is they all want their money so fast. By the way, they can do what with that NPA? They can sign it and send it back and say, yeah, I accept this. Give me the money. So sometimes, if I have a good relationship with the heirs, I'll send them out, he'll send out the letter and I'll send an email saying, listen, you got your letter. If you have any questions, let me know, because we can close in 21 days or we can close in 45 days. It's entirely up to you guys. And then some of them will say, well, what do we have to do to close sooner? So, and then you have to make sure you understand. It's like, if you agree with all the terms, you have two options. You can wait the 15 days, then by default you approve. Or if you want to speed it up, you can sign it and send it back, but we can't take any action until all heirs have responded. So that's how you handle that.
So how do you handle, what are the timeframes for court confirmation is needed? How does that work in timeframe?
Yeah, so
That's a whole other.
Hideous.
I
Hideously.
was gonna add to that, like, how do you know in advance, we see court confirmation required on a listing, like, how do you know that before you even list the house, and then what happens with the
I
court?
think what you're looking for, at least I think this high level discussion here is, does your client, the administrator of the estate, have independent authority or not? Right, and you'll know there's what are called letters of administration or letters testamentary. That's what I call the golden ticket to let the administrator kind of do whatever he or she needs to do. And on that form, is a box that says independent authority. And if that box is checked, then court confirmation is not mandatory. Could be required. And again, Judith, all those deadlines I go to a book, to be honest with you, because it doesn't happen very often. Again, in 13 years of doing this, I've never had to go through court confirmation, right? Ever.
I've had 3 that have gone, 4 that have gone to court
So
confirmation.
it's a process. I've seen it happen.
I've actually had 2.
Yeah, so again, this is when you either don't have independent authority or there's an objection, right? So when that happens, then we go through it, and all I can tell you guys is you don't want to go there, right? But if your clients have independent authority, there are no objections, then you typically can go through that process pretty smoothly.
We can- Go ahead, Rick. Go ahead.
What's the cost difference to the family if they have a trust in place versus having to go through the probate process?
Ooh, she was listening. That's a good question.
It's a huge cost.
Yeah.
I mean, I guess it also depends on who's paying, right? So I get clients, mom and dad, see me and they are wealthy, they've done really well, but as you all probably have experienced, wealthy people can be sometimes very cheap, right? And so when I say, look, parents, having a trust for our firm, we charge $4,200 for a full estate plan, all the everything covered. They look at that number and they say, I don't know about that. Let me get back to you. Okay. And then they do nothing, but they own let's say a $4 million house. Okay. If they do nothing, they pass away, probate fees are not $4,200, right? Probate fees are based off of what's called a statutory fee. So it's in the statute. I don't make this stuff up, right? And so the fee is multiple of what we would charge for an estate plan. So just as an example, for $1 million home, which good luck trying to find one of those around here, the probate fee is $23,000. That's just to the lawyer. That is not including court costs. That's not including referee fees. That's not including the fee to the administrator, who also receives $23,000 if he or she wants to take it. And that number only goes up as the assets go up. So as way of an example, I'll tell you guys, I had a probate that was worth $23 million. That fee was nearly 180 grand, right? Which all could have been avoided. But actually, this was a single person, so it could have been avoided for $3,000, $3,200.
And it doesn't even have to cost that much. I mean, there are other people who just, for people who get sticker shock and I don't want to go with the really full package, there are other options that are a little less, but still, you are so right. Oh my God,
Yeah,
180,000 for the probate
I would just
fee?
caution against that's fine that people want to explore options, but there are some services out there that just mail the
Don't
clients the
go
documents.
NOLO press.
Yeah, that just mail the clients documents and that can cause a lot of problems.
Look, anybody in here that owns a property, if you don't have a trust and you have kids, you're making a big mistake. Pay the man,
Yes.
okay?
I gotta take this down.
And work with a California state certified trust and estate specialist. There's a reason that they do that.
Yes.
Any attorney can put a trust together. A specialist can put the right one together for you that eliminates major headaches down the road. Just believe me on this. I have seen it more times than you will ever need to see in your life to understand that hire the right person, pay the right fee, and get the right results.
Yes.
Yeah, I've had people that know, mom said that there's a trust and it was never executed.
Yeah.
Oh, the best ones are, and this happens 10% of the time. Yeah, we've got a trust. Everything's right here. Not a problem. Great. House was never recorded into the trust. Property was never, so guess what happens to the house?
Yeah.
Tell them, David.
Well, generally it goes through probate.
Yeah.
I'll just pitch, there may be another way, but we need to
There's some
look at
sort of
that.
umbrella policy in
There
the trust too, to protect.
Sometimes, right? So there's sometimes a general
Protect what
assignment
you
and then there's a special procedure if it applies.
Is that Hagstead?
Yes.
So let's wrap this up with a few nuts and bolts questions for you, Rick. So from start to finish, if you took a listing today, you've had someone living in the house for 50 years, 3-bedroom, 2-bath. When would that transaction on average close?
So I take the listing, I look at the property, everything is going at light speed. Joan needs 3 to 4 weeks to clear the house. Okay, while Joan's clearing the house, I have to take a look at it and see, could the estate gain net income by improving the house that was built in 1970, fully decorated in 1974 and not touched since. Okay, could they gain from that? So then we bring in contractors and stagers and designers and we say, what can we do to this and how much would it cost? We look at all that, then we go back to the estate and say, hey, this is what we can do. This is what I think it's going to sell for as is. This is what it's going to sell for. If we do all of these things, what are your thoughts? And they look at this and they go, we could get that much more if we fixed it. How much does it cost to, ooh, so usually you're gonna probably do some work to it. So there's another 3 to 4 weeks. And then on the 4th week, your inspections are done, the staging goes in, your photography gets done. So oftentimes in a typical one that is, that's a mess, it's gonna be, 7 to 10 weeks before it goes on the market. And that 7 to 10 weeks of work that we're putting in, as this team's putting in to get the property prepared, so the estate can say net $1,100,000 instead of selling it as is and netting $1,010,000. Some of the biggest deltas I've had where we've been able to sell property for several $100,000 over what it might have sold for as is and I'd only put in 50 to 60,000.
So is it fair to say that when you're marketing yourself to attorneys and heirs, you're not marketing yourself as I'm Rick the Realtor, I'm Rick the team, and here's all my panel of experts that can help you get the most money for your asset?
Yeah, people like Joan make a big difference to what I do and the contractors that I work with. I mean, I've been doing this for a long time. I don't have any contractors work on my clients' homes that haven't worked on my own properties. And the shortest term contractor I've got now, my landscaper guy, actually died about 6 years ago. So I have a new landscaper. He's only been with me 6 years. So, well, the painter, you know, all these people, flooring people, we're talking about, 15 plus years.
So we have just a couple minutes left. Do you have, I'm gonna give each of you one opportunity to give your like one takeaway nugget. If you're a realtor, you're trying to get into this business, what's the one thing you would give them or advise them?
If I was a realtor coming,
No,
then you guys.
Yeah, no, if you're, as the attorney on the other
Oh.
side, what's the one thing you want to tell these guys?
Yeah, I think, I think the biggest thing that would be helpful when I'm talking to realtors is for them just to know just the basic details of probate sales, right? So I don't think I'm not sure how hard it is to get these certifications, but even if you don't have them, at least understanding that probate has some very specific deadlines. These are the things that we need to do, understand notice of proposed action, understand independent authority. Just kind of those basic little tidbits, I think would be really helpful when you're talking to the attorney and talking to the potential client trying to sell their home. So you can kind of give them the expectation, right? If you tell them this is like a normal sale, it's going to operate the same way, I think you're setting yourself up for a very upset client, because it doesn't always work out that way. There are lots of other people who are involved. The administrator is a fiduciary, which means you're not only looking out for yourself, you're looking out for the entire probate heir group. And so, you may not want to spend $20,000 on whatever it is. You may only want to spend $5,000 because that's going to get you the biggest reward. So I think just understanding there are some minor differences and talking to the lawyer about what those might be is the biggest benefit.
And Joan, what's your word of advice?
I think that a really good thing to tell your client, the administrator, the trustee, whoever you're working with in these estate cases, is that they don't have to do this by themselves. From the personal property and the contents of this, a lot of times if it's a family member or a friend, and basically non-professional fiduciary, not an attorney who are in those roles, they think they have to be the person to do all the work. And they don't know that there are services at all out there that help them through this. They know that there are real estate agents. They know that there are attorneys, but they don't know that there's somebody who can physically be on site to go through this stuff with them or on behalf of those people.
So to that point, your fees for that, is it based on?
We charge hourly.
Okay.
And because our scope of work changes, can change dramatically throughout the course of the project. And we just never quite know how much is going to be there, particularly if it's what we call a very dense content site, okay?
But you have to walk through sideways.
By the way, we do not, as a side note of education, please avoid the term hoarder. It's so ingrained right now in public, context that we use the word hoarder, but it's very pejorative. And I have pejorative, it's stigma.
Negative.
There is a negative connotation to that word, and it will show your sensitivity to the client if you can use the word a little differently. Here's subtle changes: hoarding environment, hoarding behavior, a lot of stuff, dense, difficulty managing your stuff, anything like that that shows that you understand that there could have been a psychological, right, a mental issue behind this, or a physical disability that prevents somebody from taking care of their stuff. There's lots of reasons behind it. Using the word hoarder is not kind in general. So that's my professional side. But if you can tell your client that, look, we have somebody who can help you get through this. we can send somebody one-on-one to work with the family to just go through and process it out, or we can be there on behalf of the estate. Figuring out what's there, getting all the things out of the closets, the shoe, checking the shoes, the pockets. That little space in the kitchen, you know, where you have to reach way back down or shine a flashlight to see what's in that way back cupboard in the corner. We look there. We look in the coffee grounds. We look everywhere to find that stuff that might be important to the family or to the estate as a document. So you don't know what you don't know. Oh, by the way, I have literature on the counter right out here if you want contact information.
Rick, any last thoughts?
If you're really looking to get into this area of real estate, the best thing I can tell you is get educated, take that probate class. If you don't have a trust for your personal property, spend the money. You're going to get two major benefits. First, you'll have a trust. Hello, that'll be a bonus. Second, you're going to learn everything there is to know about trust. So when you talk to an attorney as a prospective person who may refer you business, you will understand many of the terms that they're going to be using with you, and you can have an intelligent conversation with them. Those are the big things. Get a copy, ask an attorney to say, hey, do you have an old copy of some letters testamentary, letters of administration? Get a copy and study them, look at them. Like you said, it's a box. You check the box. They've got full independent authority under the Administration of the States Act of '87, and they can sell it. Doesn't mean it always works, but that's, you have to learn these things, okay? And those are the most important things you can do. Before you can sit down with an attorney and actually talk and have an intelligent conversation, you have to at least know the definitions of the terms they're going to use and be able to speak a little bit intelligently about what they're actually doing in their business, which is trusts and probates and estate planning.
Thank you guys so much. I think that was
Rick wants his books back.
Yeah, I gotta have those. Those are the keys to the kingdom, guys. Come on.
thank you guys so much.
Yeah.
Thank you, Rick. Hey, Rick, thank you so much. This was amazing.
Thank you, Rick.
So my when I am, so one of the things I do in the